to advocate their claims. And so the whole notion that this model that was pioneered by the Legal Defense and Education Fund would be the template for progressive lawyering was thrown into flux. Now, if you're on the other side and you're a conservative public interest organization and want to litigate for social change, federal courts start to look pretty good, but on the left they look quite constrained and even risky. So as a tactical matter, lawyers sort of started to try to avoid federal court litigation, and again I'm exaggerating, there's a bunch of stuff that's happened in that domain, but was a genuine reassessment and search for alternatives in terms of advocacy strategies. And so the federal courts were not the centerpiece of the strategy. The internal challenge to this paradigm actually, so that it came from folks who looked at it from the inside and said, this shouldn't be the way that social change occurs. And the critique really went to the issue of who's in charge of reform campaigns. And again, in a nutshell, the basic idea was that the classic paradigm gave lawyers too much power, and that they used that power to make decisions in ways that were not always in the best interest of their constituency. So there's a classic article by Harvard Law School professor Derek Bell, who famously criticized the NAACP, Legal Defense and Education Fund, for steadfastly pursuing public school integration, despite the fact that many within the African American community became disillusioned with that strategy and would have preferred local control. So this critique suggested that lawyers should take back seats to clients and communities rather than dictate the terms of the social change engagement. And this critique pointed toward sort of deeper community engagement, to local engagement, rather than sort of rarefied legal theory making and esoteric litigation strategies. So my key point here is that at the very moment that labor activism is being pushed down to the local level in search of alternative legal strategies, so too progressive social change lawyering is also undertaking its own turn to the local, pushed by the constraint on federal courts, and pulled by the lure of more democratic and collaborative social change experiences. So both of them go to the local in search of different advocacy opportunities. So the story seems sort of a match made in heaven, right? The labor activism goes local and public interest lawyering goes local. Of course it isn't, but it at least allows me, I think, to get to the heart of the project, which is really to look at this particular intersection and ask how these new sort of pluralized legal strategies have influenced the form and content of low-wage worker organizing, and how that organizing in turn has reshaped the legal strategies themselves. Okay, so it's both, sort of both. I'm asking both, how does lawyering affect organizing in the context of low-wage worker activism and vice versa. Now, so this is a moment where I say, I haven't got there yet, so there's no big payoff, and I'm disappointing you. It's a work in progress, and I'm really looking forward to your feedback. But here's some preliminary conclusions, and I want to make a few comments. I want to start with sort of the impact on the lawyering hemisphere. And I'm going to make a sort of a very descriptive point, but it's actually quite relevant to the lawyering literature, in particular its critique of the lawyer domination, the lawyers exercising too much control that I mentioned before. And so one of the point is basically that the sort of model of the court-focused litigation ideal that I suggested before is not the way that lawyering works in the context of these low-wage worker organizing campaigns. The lawyering looks very, very different. So let me just identify a few ways in which it is different. First, and importantly, it tends to be focused on legislative reform rather than court-based reform. So most of these campaigns are ones in which the coalitions are trying to get mostly the local legislature, but sometimes also the state legislature, to pass laws that benefit their constituency. Litigation still tends to be used, but it's generally used defensively. So what happens is that the coalition is successful in getting a law passed, the lawyers help in drafting and sort of vetting the legality of the law, and then opponents of the law bring a lawsuit to try to challenge it and knock it down, and the lawyers then have to go to court in order to defend its legality. So that's the sort of the paradigm. So it's do the legislature first, and then use the courts to defend the legislative action, as opposed to going to courts first and asking the court to articulate a ruling on the merits. Okay. So the second point is that these campaigns tend to be conducted by lawyers who are sort of working in teams. So again, the sort of classic paradigm is the lawyer in the nonprofit organization, the NAACP, that identifies the issue and litigates with the latter. Here, the lawyer teams are more fluid, and they tend to be lawyers that work across different practice sites. So some of them are in private firms, some of them are actually in government practice, and some of them are in fact in nonprofit organizations, and they tend to be relatively deferential to their clients' interests. These are situations, and this is the third point, where the client organizations are relatively strong, and they have formulated the campaign goals, and they have a strong ability to dictate the outcome. So clients are strong, lawyers are relatively weak, lawyers are advancing the interests of the campaign that the clients articulate, which again is a flip of the classic social change paradigm. Just as an example, the current campaign around the LA and Long Beach ports, are any of you familiar with that? Yeah, I'm saying no, you are. So just as a basis of comparison and to illustrate this particular dynamic, so this is a campaign that's run by Lane. Coalition came together around the goal of cleaning up the ports by changing the employment structure of the trucking industry, under which trucking companies hired drivers as independent contractors who ended up being too economically marginal to afford sort of consistent truck maintenance, and to upgrade their trucks. They became huge sources of diesel pollution, making the LA Long Beach ports the biggest source of air pollution in the LA basin. So the campaign goal was to change the local rules governing port drayage, and drayage is basically the rules under which trucks can haul goods to and from the ports. And the idea was to change the basic rules covering these truck shipping in order to enhance environmental and labor law compliance. So a big coalition was formed and included a bunch of different community organizations. It included labor, centrally the Teamsters, it included Lane, and it included a bunch of environmental organizations, including critically the Natural Resources Defense Council, NRDC. They got together, they drafted new rules that required trucking companies to hire their truckers as employees as opposed to independent contractors, and to retrofit or upgrade their trucks as a condition of actually being able to enter the port. So the legal rules of the drayage agreement, the shipping agreement under which trucking companies access the ports, were changed in order to convert the truckers into employees and to require the trucks to be upgraded and retrofitted so that they would be clean, they wouldn't cause such terrible pollution. And so the labor goal was to allow the truckers to be employees so that they could then be unionized by the Teamsters. Okay, so a very powerful, diverse coalition. It enacts legislative reform to promote sort of twin goals of labor organizing and environmental quality. Turns out that as soon as they get the law passed and approved by City Council, the trucking industry sues to hold it up, and they argue that it's preempted by federal law. They actually are successful on a couple of the provisions. The case was just in trial at the trial court last week, and the campaign is now in Washington, D.C. in front of Congress trying to craft different rules that will allow them to advance their goals. So the model doesn't guarantee success. So here, even though they were able to initially get the legislative fix, the trucking industry was able to go to court and block crucial portions of it, particularly the conversion of the truck drivers to employees. But that story hasn't ended yet. They're still litigating different components of it, and they're trying to get a legislative fix through Congress. So they actually have gone back up to the federal level for obvious reasons in different administration. But so the model isn't necessarily always successful, but it looks very different. It's very differently targeted than the sort of classic court-centered approach. Okay, and we can